Hi, I'm Jeff Bellomo with Bellomo Associates. Wanted to take a minute and talk a little bit about a recent trend that we are seeing. For those of you who work with our firm or any advisors that have referred to our office, you know that asset protection is extremely important. We can do asset protection during life and after death. Now, during life, not everybody needs it. Not everybody has the assets that they're able to fund into the trust to protect the assets during life. So that's a conversation that we have with each and every client to see if it's a fit for them. But equally as important, we like to protect the assets after death. And we have been very fortunate that we have been able to do that through the use of a testamentary trust under a will. The other way you could do it is through a living trust, whether it be a revocable living trust or an irrevocable asset protection trust. For 20 years, we have been able to use a will, put a testamentary trust into the will, providing asset protection for the spouse, for the children, for the beneficiaries. Over the last 6 months, we are seeing a complete change in the industry, a complete trend that is concerning us in that financial institutions, brokerage houses, people that manage the assets are not wanting to be able to name a testamentary trust as a beneficiary. They want it to be a living trust. They want it to have an ID number. They want it to be alive today, even though it doesn't actually take effect until after a person dies. I recently had a conversation with one financial advisor who was told from her person that she works with that it's because there was some scams and things that occurred and they want to protect people. I wasn't aware of that. I had not heard that that was an issue, but she directly asked the question to her wholesaler when they would not change a beneficiary designation of one of her clients to the testamentary trust. Regardless of the reason, it is certainly a trend that we are seeing, and what I think you're going to see is going to be happening is the use of living trusts, the use of revocable trusts are going to take on a new meaning in the state of Pennsylvania. For years, I have been saying they weren't necessary. They were an extra cost that wasn't going to provide a great benefit because we could do everything through the will. Probate was a fairly straightforward process in Pennsylvania, not a lot of costs. Well, now with them not wanting to be able to name a testamentary trust under a will, we're left no choice. Now, what we are going to see is people who want to protect assets after death are going to have to do that through the use of a revocable or irrevocable trust. Not a big deal, not a huge change. It certainly is going to continue in the future, and I think you're going to see more and more of it. And part of the reason is because they won't allow us to fund testamentary trusts during life for something that doesn't actually get created until death. So I wanted to just hop on here and let you know that so that if you're starting to see that as well, or if you're coming to one of our workshops and you're noticing a change in our language, that's why. That's why it's occurring. And unfortunately, we do not have another way around it. So that is what you will see. Now, the good news is that although revocable trust may be a little more expensive on the front end, they're definitely cheaper on the back end. So a lot of lawyers are using them as a way to save people money on the back end. And so that is the good news in this situation. Although you'll pay a little more up front, you'll certainly save on the back end as well. So we look forward to working with you. We look forward to talking to you further. Please come to one of our weekly workshops on estate planning and elder law. We would love to see you and work with you sometime in the near future. Have a wonderful day.